Consumer Counterpoint. I'm your host, Christine Argentine. I work at Cypher Shaw and partner in the Chicago office. I'm joined today by a guest, Danny Riley. I'll let him introduce himself.
Yeah, thanks so much for having me, Christine. I'm very excited to be here. This is my first live podcast or video cast, so really excited and honored to be here. My name's Danny Riley. I am an associate in the Cypher Chicago office with our litigation department. I work on a number of things, a lot of them having to do with data privacy and compliance. A good chunk of my work is privacy compliance work. So kind of the other side of litigation, more preparation and taking a look at clients' websites, products, and making sure they are up to the standard for consumer protection.
Right. Super important, right? And it's something that we've talked about on this video cast a ton in terms of how do we mitigate the risks associated with enforcement or litigation. So today we are covering opt-outs. Is that right?
Opt-outs,
okay.
Yes.
So tell us a little bit about kind of, for our audience, talk about what an opt-out is and what regulations we're really focusing on.
Yeah, so with consumer protection, obviously California is the big one. A number of states have kind of followed suit, but I think before we get to opt-outs, we need to talk about just compliance obligations the last few years.
Great.
The California regulators have really looked at putting in a number of regulations to make compliance measures a little clearer for businesses. So having a privacy notice, a notice at collection, all of these kind of written disclosures for transparency.
And we're talking about on consumer-facing websites, right?
Yes.
Okay.
So anytime you put in your email or show up at a website, that's why we see these privacy policies coming up on our phones, really with any website that we go to. In recent months, there has been a real push into kind of operationalizing those compliance measures. You say one thing, but does it actually work this way? So opt-out rights, which are common across our comprehensive state privacy laws, allow consumers to opt out of the selling or sharing of their information. This kind of plays into Christine and Paul's conversation on cookies, because anytime you log into a website and there's cookies or pixels or web beacons, your IP address and email and information gets shared for marketing purposes.
Yes, and we've talked about that a lot in terms of, you know, how these different websites have to communicate with each other and what type of information needs to be transferred in order for that network to network communication to happen. And it is like those IP addresses, the information that you're talking about.
Yeah, absolutely. And there are a lot of things on the business side where it's great for marketing and analytics. And on the consumer side, it's the reason I can go put something in a cart and come back 2 days later and that pair of jeans is still in the cart. Sure. So there's kind of a balancing act of privacy and respecting the privacy of consumers, and also getting the most out of website traffic and business. And that's really what the regulators are looking at enforcing right now. And they're conducting regulatory sweeps and investigations into, okay, you're doing this stuff, but are you allowing your consumers to opt out and to have the rights that these privacy laws are affording to them?
Okay, so let's talk about California first. What is the law that's governing kind of that space that regulators are enforcing under?
Yeah, so that's the California Consumer Privacy Act, the CCPA, as amended by the CPRA. And essentially that is governing the collection and use of personal information.
Okay, and what is the opt-out requirement there for businesses to know about?
Yeah, so the opt-out requirement is if you are collecting information that you are selling or sharing with a third party, you have to have an option for the consumer to go in and say, I would like for you not to share my information with any vendors, third parties, whatever it may be. And historically, this has been either through an email address or a toll-free phone number. You need to give these options to the consumers, and they say make it seamless, make it easy. Recently, there's kind of a push towards automating that. So if I were to opt out on my browser through a global privacy control, then websites are technically supposed to be respecting those choices, which is creating kind of a technical difficulty for a lot of businesses that might not have their IT in order. It can kind of clash.
So talk about what is a global privacy control. What is that? That's not the cookie banner. That's something different.
No, so the global privacy control is essentially, it's called an opt-out signal. So these are web signals that browsers should pick up to see this person's choice is to never share my information with third parties. Obviously, that's difficult when it comes to the implementation phase. Something that is also interesting is a lot of businesses have these. They're required to have an email, a toll-free number, some sort of web form to fill out in order to opt out.
Okay.
But with the big push from California and Colorado and Connecticut, these regulators saying you need to respect these browser level opt-outs, it can be quite difficult in practice because someone might set their global privacy control as this and think they're okay. And if the business does not have that working right, and they don't receive an email or a call, there's conflicting opt-outs, essentially. And that's kind of an interesting difficulty in reality with implementing and being compliant with some of these rules.
Okay, so what do businesses do to make sure that they are in compliance? Are there steps that they can take?
Absolutely. So I think the number one thing, and I think this is also relevant to SIPA compliance and for litigation, just risk tolerance, is you want to just do a routine health check. You want to go to your website as a user, either on your phone or have someone on your team look and see what are we saying we're collecting and what is actually being collected. If someone goes to your website and says reject all cookies, are those cookies still firing? So the number one thing is see what you're saying and see if what you're saying is actually happening.
Yeah.
On the more technical side, you just kind of want to get the house in order. You want your data flows and your information governance to be up to par. What are we collecting? Where are we keeping it? And how can we manage that? Because if the consents you get lost in translation when a regulator comes knocking or a plaintiff's firm sends you a demand letter, that's information you're going to need to have in order so you can defend your case and explain what you were doing.
Yeah, and this is something that Paul and I have talked about a lot when we're talking about these types of privacy cases, right? And you mentioned it earlier, like transparency is key and functionality is key, right? If you say your website is doing something, it needs to be doing that, right? Or we kind of fall into this almost unintentional deceptive behavior, right? Because let's talk for a second about vendors, right? Because most businesses don't have the Marcom team or the IT team that is fully operating their website. They are hiring outside parties to implement those cookie banners, those security measures, even basic functionalities on the website. So talk to me about how this interplays with the use of vendors when those are the companies that businesses might be relying on to make sure that the functionality is there.
Right. That's a great question, and it's extremely relevant to recent investigations and fines that have been going out, where regulators have made clear it is on the business. It is certainly helpful to have these vendors that help you implement your cookie banner, but ultimately it's on you to make sure whatever you're saying in your transparency notices lines up with the functionality. So we've had recent fines going out to these companies, $500,000, over $1 million, and there is no defense really for kind of sending that work out if you're not actually backing it up.
Yeah. Yeah, I mean, and we've seen this too in like the TCPA space, right? Lots of companies use vendors' platforms to do their marketing on TCPA, and it's not a defense, right? If the vendor implements something that creates a TCPA violation, it doesn't protect the company from that lawsuit. Now, maybe you've got indemnification provisions in place. Right. All of those things help. So you always want to look at your contracts with vendors and make sure you're protected on that end, but it doesn't actually stop the regulators from coming. It doesn't stop the lawsuits from coming.
Certainly. And I think on the piece about contracts, to the extent information is being shared for your product or for your website, and a consumer opts out, you need to have contractual controls in place with those third parties to say, if you will uphold these compliance obligations to the same level we are. Meaning, if we have an opt-out, you will also make sure to, whatever it may be, delete the information or assist with whatever consumer right is being used at the time.
Okay. So we've talked about California. California is obviously a big one. We talk about California on this videocast quite often because there's a lot of litigation there, a lot of regulation there. What about other states? Are there other states that companies need to be aware of where there's really specific guidance or regulations with respect to these opt-outs?
Certainly. I think Colorado has been very active in the space, and it is explicitly required. Global privacy controls are required. You have to respect those. And generally, what we're seeing across the U.S. for the last few years now is states just following in California's footsteps, especially on the consumer side. These are all consumer privacy laws. California, of course, has the employment, they consider employees to be consumers. But states are following suit, and we're seeing more regulatory action out of states like Colorado and Connecticut. Those are kind of leaders behind California. Really, California's the big one, as we know.
Yeah. Yeah, I mean, I think, it's interesting because we're talking about opt-out today, meaning the consumer has to specifically say, I don't want my information to shared. And otherwise, if they don't say that, they are automatically opted in. Is that right?
Right. And that's generally how it works in the U.S. from a compliance perspective with these regulations. Where it's interesting is on the litigation front with these wiretapping laws. Can you tell us? That's more of an opt-in situation.
That's right. That's right. And so, companies are dealing with this crossover of, and often when we're talking to companies about the wiretap litigation, they say, well, we're CCPA compliant. So what's the problem? And the problem really is like the wiretap statutes talk about affirmative consent, right? Whether that's implied or, absolute check this box consent. It's affirmative, right? You can't assume someone is opted in that space. And so, it's a struggle there, right? And so now we're seeing companies put up all these cookie banners and forcing the consumer to make a choice, which isn't required under CCPA, but it is kind of that mitigation effort, that low-hanging fruit step that you can take to try to combat or protect against these other litigations that are happening in the class action space.
Right, and I think what's really interesting about that is if you operate a website, most businesses now, your website's probably going to be showing up in California, whether you're located, So CCPA is interesting because there are certain thresholds all of these state privacy laws. There are certain thresholds to be within kind of that compliance realm where you could be fined for not complying. On the other hand, it's open season for any website that is popping up in California. You could get a demand letter.
Right.
And so there's CCPA and other state law compliance, but then there's also risk, the risk of litigation.
Right.
Which can be costly just to settle or just to prove maybe you were doing it right. But when that demand letter comes to your door, there's going to be a cost there.
There's a cost to that, right?
Yeah.
And I think, one thing that you were talking about earlier in terms of functionality, operational audits, is the same is true for these cookie banners in CIPA world and these wiretap cases, because having the cookie banner isn't enough, right? That cookie banner has to function as you say it's functioning. In other words, if I hit reject all on that cookie banner, those marketing pixels shouldn't be firing.
Right.
Or if I go and customize my cookies, right, and I say I'll allow analytics but not marketing, or I'll allow marketing but not analytics, right? The functionality of that application has to work correctly, or we see, new lawsuits that are saying this is a deceptive practice. I said you couldn't collect my marketing information, collect information about my browsing history, and you did anyways.
Right.
And I didn't know you did anyways, right? That's the trick there. And I think that's probably it's very problematic on the litigation side, but also I'm sure very problematic in the regulation side.
Yeah, but there's risk from both sides, on the front end, on the back end, and I think it all comes back to the same thing, whether it's a regulator testing your website or whether it's a plaintiff testing your website. Be the first to do a health check and check in and just make sure everything is working, and that's step one.
Yeah. And I know, we're running in on time here, so we're gonna, stop for today, but we haven't touched GDPR. Right? And I think that the reality of that is that companies that are running national websites are probably running websites beyond the United States, right? They're selling their products all over the place, and those websites are able to be accessed from anywhere for the most part. And so, GDPR has its own whole set of regulations that kind of come into effect here.
Absolutely. And it really just a different approach from regulators in Europe. So there is it's kind of another level of a standard that consumers have for the companies and the websites they're going to. So
yeah,
that's for another time.
That is. So Danny, thanks so much for joining us today. Yeah. We'll have you back to talk about some of those other pieces, but we appreciate your time today.
Great. Thanks so much, Christine.